Honorable Judge Thaxton presiding.
Okay. You may now be seated. We will now hear the following cases in order. Park versus Pennsylvania, Mills versus Board of Education, Raleigh versus Hendrick Henderson School District, and Daniel R.R. versus Board of Education. Park in Pennsylvania, you're up.
Okay, so basically Park versus Pennsylvania. Park is spelled P-A-R-C, and it stands for Pennsylvania Association for Retarded Citizens. And this group was started by a group of parents who had children with mental disabilities. The children ranged in ages of 6 to 21, and they were not allowed to go to public schools. Well, the problem with that is there's this little thing called the Constitution, and that was kind of breaking their rights with the 14th Amendment, who gives the same rights to everyone. So this case was argued in 1971. Like I said, these children were deemed by the state ineligible for public education because they didn't have basically the mental age of at least 5 years old. So the options they gave the parents were you could just homeschool your kids, which I'm a big advocate for, but that doesn't work for everyone. You could put them in private school because everyone knows that's affordable, or you could just put them in an institution and leave them there. So basically, like I said, the issue was the 14th Amendment. They were not given the same rights as everyone else. And the arguments that basically the 13 school districts were giving was that they didn't have to give education to the children because they didn't have a certain mental age, and that a teacher could just say, okay, this child is not eligible for school. The holdings were, well, in the end, the judgment was for the plaintiffs, and I can't read my own writing, I apologize. Basically what it came down to was a consent decree, which in legal terms that means that the school boards agreed to give the rights to the children and the criminal charges were dropped. Out of all this came what the IDEA group had talked about. The FAPE came out of this, which again stands for Free Appropriate Public Education.
All right, Mills versus Board of Education.
Okay, this is about the right to special education. It occurred in 1972, and it builds off of the Park case. Basically, it was a group of students, a big group of students in Washington, D.C. who were not getting the appropriate education. So when the court case started and it came to session, the Washington, D.C. public schools sent 7 children to represent the over 18,000 children who were denied public education in the schools. And the plaintiffs were arguing that children were being excluded from school without equal protection of law and due process of law, and excluding, expelling, or transferring students out of classes in public schools denied them due process of law. And the defendants were arguing that the districts provided them with programming, but there weren't enough funds to give them what they wanted. And the issue building off of the Park case was, were they violating the 14th Amendment, which talks about equal protection? And basically the court ordered the schools to provide all children with disabilities a publicly supported education. It ordered the district to provide due process safeguards, and it outlined due process procedures for labeling, placement, and exclusion of students with disabilities from school. And what came out of this is the development, it's of PL 94142, and it helped develop for labeling, placement, and exclusionary stages of decision-making, and parental rights to a hearing, appeal, and records access. So basically, it was just a build-off of the Park case, very similar situation, and it was for getting students to have the appropriate rights in schools.